Ross, I can't believe it.
Yes, I know. It's good to be back. It's hip to be square and all of that. I mean, it's so good to be back. I mean, I could barely find the studio door. It's been such a long time.
When I'm out on a walk with my tree lady talk, and I can tell you I'm in my...
Great to be interviewing Julian Forbes-Laird again. You may remember he was on Series 2, Episode 7, and Another Thing. You may remember Julian turned up in court something like this.
All rise! Court in session!
Julian Drummond, Durden, Hollandby, you stand before this court today charged with the unlawful removal of a woodland subject to DPO restrictions. How do you plead?
Once again, I would stress that the advice is not clear. I've said this time and time.
Okay, class, well, pay attention now because I will be asking questions later. Underhill, stop staring out of the window. I did put something together earlier as a sort of a crib sheet so that you can sort of try and follow along, but you'll be a little bit ahead of the game. So have a listen to this. This is what I put together slightly earlier on today. For those listeners of a fragile disposition, please be aware that the following edition of Tree Lady Talks will contain the following.
The Forestry Act 1967, Section 15.1, Section 15.5, Section 15.6.
It will also contain words or phrases, including but not limited to...
Felling license, the Forestry Commission. 9,000 cubic meters of timber. A felling license granted under extremely shady terms. And the words, fraudulently, statutory background, lied, prosecutorial jurisdiction. And a phrase that lives in my memory, no such thing as a tree preservation order consent relating to a tree where a felling license would be required. Huh?
Confused? Well, you don't need to be, because here he is. Let's get him in. It's Julian Forbes-Laird.
Welcome back to Julian Forbes-Laird. Julian, we're so excited to have you on the podcast again because you are our highest ranking, fastest downloading, continuingly downloading podcast. And it really set the industry on fire. Julian, could you start off, please, telling us a little bit about yourself?
Yeah, sure. Hi, Sharon. Thanks for having me back. So I'm an arboricultural consultant, and the bulk of my work, for some reason, appears to be adversarial. So this could be in relation to planning or litigation, or indeed tree preservation order prosecutions. In terms of litigation, it regularly involves accident investigations, unfortunately, which we could all do without, I think. And in terms of the planning side, it's mostly public inquiry based work. So I've been an arboriculturist. Well, if I include my time as a climbing arborist since 1990, which is quite a long time ago now. So I had 10 years on the tools, and then I've been a consultant since 2000.
Well, Julian, you had a bit of an interesting background before then as well, didn't you? Two almost diverging interests and professions.
I studied for a master's in war studies and international relations at King's College London. I was going to be a defence analyst before the end of history and the permanent peace that we were promised would result from the Berlin Wall coming down and the collapse of the Iron Curtain. I happened at the time to be working to pay my way on the master's course for a local tree surgeon. And so I just sort of stayed doing that. I would say I've never looked back, but maybe I've never looked forwards. We'll see.
So the subject of their previous podcast was really Operations Note number 52 by the Forestry Commission, which sounds like the most boring title for any podcast out this week. But actually, it really struck a chord with people. And since that first podcast last year, there has been a decision in the courts. I wonder if you could, to start with, for the listeners, give a background on why this is such an important issue.
Yeah, sure. So this dates back to the grant in 2016 of a felling license by the Forestry Commission to Highways England Limited, which at that time was a separate company, wasn't again a pure agency of the government, even though it was wholly owned by the government. And this felling license concerned trees on the trunk route network as far away as almost 200 meters from the roads to which they loosely related. And the felling license was granted under extremely shady terms. So the first thing that happened was Highways England Limited and the Forestry Commission entered into a memorandum of understanding of how the relationship between these two would be governed. And on the back of that, the Highways England Limited applied for a felling license, and with the full knowledge of the Forestry Commission, fraudulently omitted to check and notify the Commission as to whether any tree preservation orders or conservation areas applied to the trees within the scope of the felling license. Now, if you imagine a felling license covering all trunk roots in England, you could well imagine there'd be many, many hundreds of tree preservation orders, possibly thousands, and/or conservation areas covering the trees concerned. So, as a matter of complete bewilderment on the application form for the felling license, to the question, are there any TPO or conservation area protections in force, Highways England Limited ticked no when they hadn't checked. Forestry Commission knew they hadn't checked. And the felling license was therefore granted on terms that were knowingly fraudulent. And this really matters because it is only upon that box being ticked yes that the Forestry Commission notify local authorities that they're going to grant a felling license, if that's what they're going to do, as it was in this case. And then the local authorities, per section 15.1 of the Forestry Act 1967, become a consultee party to the felling license application. This enables local authorities to object to the grant of a felling license, whereupon the authority to grant such is removed from Forestry Commission and placed with the Secretary of State in what effectively becomes a tree preservation order appeal. Also, Forestry Commission has the power to refer felling licenses for determination to authorities. It's a separate mechanism, doesn't concern us here. So what does concern us here is the, I keep using this word, but it is the right word, the fraudulent prevention of local authorities from being consultee to tree preservation orders affected, or trees under preservation order affected by felling license applications. Now, they sought to square the circle by attaching a note on this felling license that said, oh, it doesn't cover TPO trees and conservation area trees, and you must still apply for consent from the relevant local authority before taking such trees down. But of course, firstly, there is no power in law for that rider to be applied to the felling license because section 15.6 of the Forestry Act 67 makes it clear that when a felling license is granted, it's irrevocable in respect of trees covered by preservation orders or conservation areas. But even more importantly, section 15.5 of Forestry Act 1967 prevents local authorities from even entertaining applications for felling of trees where those trees are subject to the requirement of a license at section 9.1 of the Forestry Act. So in other words, they are statutorily disbarred from managing a TPO application and or granting a TPO consent. There is therefore no such thing as a tree preservation order consent relating to a tree where a felling license would otherwise be required. That is the statutory background. And I came across this approached by a client who was being prosecuted by a local planning authority for felling trees subject to a tree preservation order, where those trees were A, requiring of a license under section 9.1 of Forestry Act 1967, and B, benefiting from a felling license, namely the Highways England felling license. So these trees already had the protection of section 15.6 felling license being granted on TPO trees. The local authority knew nothing about the Highways England felling license. And the first thing it quite properly did when it was told that areas of woodland were being felled, allegedly by my client, they contacted the Forestry Commission and said, have you got a felling license? And the Forestry Commission said, no, there are no permissions for felling in force at this site. So it lied. So when we were able to find and produce the felling license and show to the Forestry Commission, so, well, there is a felling license, so could you please change what you've said to the local authority because they're about to prosecute my client who thinks there isn't by saying there's no license. Then they said, oh, well, the felling license doesn't apply to your client because the name on it is Highways England Limited.
There'll be lots of land up and down the highway, which isn't within the ownership of the Highway Authority, but the Highway Act still applies.
Exactly.
That's rather strange.
Yeah. So the Forestry Commission sought to say that felling licenses stay with the applicant on the license. They don't
Right.
stay with the land. But that's contrary to A, what we all know to be true,
That's exactly right.
and B, Forestry Commission's own published guidance, which says that if you transfer your land, the felling license transfers to the new owner, and the new owner is advised to tell the Commission that it now has the land and the felling license, but it's not under an obligation of law to do. This certainly doesn't stay with the applicant. So the Commission sought to maintain this and say, therefore, our client didn't have the right to implement the license because he wasn't the applicant, which is a completely new position to take.
So when one applies for a felling license, you have to draw a polygon on a plan, and that is the area which you're applying for. You fill in the applicant details, but it rests with the land, not with the owner.
Oh, absolutely.
I'd like to also ask you a question before we go on about this specific case. This felling licence that was granted by Highways England, has that expired or is it still current?
It's expired now.
Do we know the impact of that felling licence? Do we know how many trees were felled? Is there any record?
No. I don't have any information about that. All I can say is that it covered over 9,000 cubic meters of timber, which is not insignificant amount.
And you don't know of any cases where there's been some trees protected by a tree preservation order or within conservation areas where there's been felling of those trees by Highways England? No, so there's no data on that.
I can't help you.
No, okay.
Yeah, there may well be information out there, but I just don't have it.
Do you know if that felling license is going to be renewed by Highways? Is the same thing going to happen again?
I don't think it will, because they've had their fingers very badly burned as a result of this, and whatever else happens, I don't think it'll be. If a new license were granted, it wouldn't be granted in the same way, and wouldn't be granted with the without the necessary checks. That's my personal view. It'd be amazing if they tried to pull the same stunt a second time, but I don't think they will.
Okay, thank you. I just wanted to put that in context. But do carry on with this case. Okay,
so we demonstrated that there was a felling license, and then we argued the point that the felling license ran with the land and not with the applicant, which the Forestry Commission didn't at the time accept. So there's then the question of saying, well, the local authority doesn't have prosecutorial jurisdiction because it's not able to even entertain an application for TPO consent, because of section 15.5 of Forestry Act 67. So if it can't grant consent, how can it possibly prosecute for an absence of consent? My point on this is that one cannot criminalize failure by the citizen to pass an impossible test. And that is the logical position the local authority were seeking to take, and it just seemed a nonsense to me. So in July 2020, the Forestry Commission published its operations note number 52, which is called Felling Licenses and Tree Preservation Orders. And this note sought to clarify the law on these matters. But the reality was, it's almost certain that note was prepared to shore up this particular case, because it related to just so specifically the issues at hand. It would be a very striking coincidence otherwise. And in the note, it says, consider the following scenario. Trees subject to a TPO are felled. The felling was of a scale where a license would ordinarily be required. Neither a felling license nor local authority consent to fell the trees subject to the TPO is in place. So that's the scenario.
For those who aren't familiar, we're talking about the timber being of such a scale that the felling license is required. Just to put that into context, we're talking about one really large tree, or two or three medium-sized trees in what we call a calendar quarter, which is obviously January to March, etc. It's really not very many trees. And for those who are listening outside of the UK, a felling license isn't needed in somebody's private garden, and it isn't needed if somebody's got planning permission and those trees are shown removed on an approved drawing. But it is needed in, say, an industrial estate or brownfield development before planning applications put in. It's not just a farmer's land. It's not just a woodland up in Scotland. You know, it is everywhere, apart from a very few exclusions, such as churchyards, private gardens, some types of designated public open space. So we're not talking about lots of trees in rural areas. It could be within any town, apart from the centre of London boroughs. It's really everywhere. And I know that this isn't widely understood in conversations I have with clients. So I just wanted to put that in context with this operations note.
So I've set the scene from the operations note. They've come up with a scenario of trees subject to a TPO being felled that would have required a felling license, and neither TPO consent nor felling license was granted. And so the operations note advises that, and I'm quoting, 2 offences are committed in the above scenario. An offence is committed in relation to felling without an approved felling license, where one was required per section 17 of the Forestry Act. In addition to this, despite the local authority being unable to grant TPO consent directly, the absence of an approved felling license means that TPO consent is needed, and therefore an offence is committed under Town and Country Planning Act as well. So what they've done is they've got apples and oranges, comparing apples and oranges, and they've sort of made some kind of rather unpleasant fruit salad out of this thing. And it's absolutely a legal nonsense.
Well, it is an illegal nonsense, but it's widely practiced.
Yes, it is. Oh, absolutely. Because most local authorities don't know this.
For example, they don't know it. They expect a TPO application if it needs a felling license. They expect that and they will issue that. This is common and widespread, as we will find out, malpractice.
Yeah, absolutely. So that was the advice in the operations note, and most interestingly, that advice flatly contradicted the advice given by the Forestry Commission's regulations management team in another case, in a case within Warwick District where this precise issue came up, and Warwick District were shaping up to prosecute somebody. They prayed in aid to this aspect of the law. And the Forestry Commission, at their request, wrote to the local authority and said, no, actually, you can't prosecute because you don't have jurisdiction because of Section 15.5 of the Forestry Act, and the trees had a felling license. So that's that. So they contradicted their own published guidance, and well, of course, everybody's allowed to change their mind, which is what they said they had done. However, for that to be right, it would have led to this difficulty that I mentioned earlier of criminalizing the failure by a citizen to pass an impossible test. And quite clearly that's contrary to natural justice, and it just simply can't be a thing. So the local authority prosecuting went ahead with the prosecution, shored up by the Forestry Commission's stated opinions on these matters, and we were due to go to court. So what happened next was the defense filed an abuse of process motion with the court. So what this said was it invited the court to accept that the attempt to prosecute was an abuse of the process of the court. In other words, it was, if you like, a manipulation of the court.
Mm-hmm.
And abuse of process motions are, I'm told, as rare as hen's teeth, and those that do go before the courts almost invariably fail. Getting one over the line is seriously uncommon. That's what the barrister in this particular case said. Jonathan Ashley Norman QC. That was what he said. So the abuse of process hearing had not happened when you and I last spoke.
Mm-hmm. I know, this is why it's so interesting and very important.
So now we're up to date by the end of the previous podcast, and so we can see what happened in court. So the prosecution called 2 witnesses. And they were both from the Forestry Commission. Quite remarkable, both from the Forestry Commission. One was a person who was junior to the other within the particular department, the Regulations Management Department.
Can I ask a question here, Julian? Was that department in the same area, regional area?
It's head office. It's a sort of central department. Yeah.
Mm-hmm.
Yeah. They asked questions of these 2. The more junior person went first, and on the thorny subject of felling licenses running with the land or staying with the applicant, the more junior of the 2 said that it stays with the applicant, so that if the land is transferred, the new owner has no entitlement to enact the felling license. 10 minutes later, we then have the more senior of the two Forestry Commission staff members on, who says the opposite, which was quite an amusing moment in court and caused some raising of the judicial eyebrow, because normally if you get two witnesses on, they don't contradict each other, but they did in this particular case. So that was an interesting piece of theatre. But anyway, the defence laid out its position on the law and made the points that I have referred you to already. And then we all went away again and we waited for the judge's decision. And she concluded that the attempt of prosecution under the circumstances was indeed an abuse of the process of the court. And she said that if she was wrong, then alternatively, the offence that was being attempted to prosecute was one that was unknown to law, because there was no route that was navigable from the Forestry Act back to the Town and Country Planning Act. So that if an offence had been committed, the offence was felling of trees without a licence, except that in this case, there was a licence, and not felling of trees subject to a TPO without consent, because no consent was available.
So in other words, if somebody fells a tree protected by a tree preservation order, but it has a felling licence, the local authority has had their chance to raise an objection to the original felling licence,
Well,
which is an interesting matter, isn't it? And not straightforward.
The local authority might have had its chance if the application for the first felling licence in the first place had declared the existence of the tree preservation order.
Exactly.
But in this particular case, of course, that was never done. So therein lies the problem with this particular felling licence. So there we are. The prosecution was stayed. My client was, the defendant was discharged. And there is then the question of what happens next. The first thing that happened next was a costs application was submitted to the court, which the judge duly considered. And she ruled in favour of the discharged defendant, awarding him £102,000 of costs against the local planning authority concerned. So that is that's caused senior officers and hopefully members to sit up and take notice and ask some questions as to why this prosecution was allowed to go forward as far as it was.
This is Tree Lady Talks, and I'm Sharon Durdant-Hollenby. All music and production is by Noel Durdant-Hollenby, and all views expressed by me or the interviewees are entirely personal.
So that's where we got to in that particular case. But by then, I had a second case pending. The second case concerned, I refer to it as a rotten borough. We'll leave it at that. And this particular local authority had been notified of the felling of a handful of trees on the edge of a woodland. Those trees were subject to a tree preservation order.
Just for the listeners here, you say they've been notified that they were going to be felled. By that, you mean the Forestry Commission?
Oh, sorry, forgive me. No, so they've been notified that they were being felled. So people had people had called the local authority and said, we're worried because trees are being felled in this woodland.
Yes, and that happens a lot when you're a tree officer. So I used to be a tree officer, and you get calls from people saying this is happening now, and you go and investigate. But in terms of the consultation process from the Forestry Commission to the local authorities, years ago, the Forestry Commission would send a weekly list. But now that doesn't happen, does it? The onus is on the hardworking tree officer who's probably got 4 million things on his or her plate to actually check that themselves. So actually there isn't the procedure is still there, but there aren't the safeguards, there aren't the check systems unless they put them in themselves. So it's actually not as straightforward as it used to be. Would you agree with that?
Oh, absolutely, because the requirement in the law is for the Forestry Commission to notify the local authority if it intends to grant a felling licence on trees over which the local authority might think they have jurisdiction. Now this notification of vertical commas is simply publishing it on the Forestry Commission's website.
Yes.
So it has ceased being an active thing and is now on the Forestry Commission's part, and now is an active task for the tree officers. And,
Yes.
I fully expect many tree officers don't actually check very often because it's onerous, as you say, and they just don't have the time.
No.
In this particular case, the trees were being felled because of a chain of correspondence started by local residents who worried about the safety of them. The manager of the estate, who'd been in post for some 15 years, went to have a look at the trees, and he had a very good working knowledge of trees, so he wasn't a specialist, and he thought they looked pretty ropey. So he got in a firm of tree and landscape contractors. The owner of the firm came and had a look at the trees, and he thought they looked unsafe as well, but he wasn't an arboriculturist. So he then got in an arboriculturist to do the climbing arborist to do the work, and certain trees were pruned and certain trees were felled. I think 4 or 5 from memory were felled. But the whole point was it was a safety-led operation. That was why it was being done.
On that point, Julian, I just wonder if we could just explain to people some of the exemptions, the requirement for a felling license. So if a tree is immediately hazardous and can be deemed to be so by either, if it's so obvious to the layman, or if it needs a bit more investigation by somebody trained in arboriculture, there is an exemption, but not for ash dieback, not for disease.
Under the Forestry Act, the exemption is felling for the prevention of danger. So these are trees which were considered by all those involved at this time to fall within that exemption. It's worth also pointing out that the local residents who are concerned with the safety of the trees lived in relatively recently built houses. And it occurred to me that maybe at the time of the houses were granted planning permission, some 3 or 4 years previously, possibly there'd been a tree survey. So I went on the local authority's website and I found the tree survey, and it's identified these trees as having significant structural issues. 2 of the 5 were graded U, as in unretainable in viable condition. And the consulting tree officer on the planning application noted with approval the tree survey, accepted its findings, and even commented that some of the trees were in poor condition. The same tree officer, by the way, who was central in moving the prosecution for the felling of the same trees.
Wow.
Now, but let's see why that happened. So why that happened was the estate had no knowledge of this tree preservation order, which dated back to early 1950s. It just hadn't appeared on its radar. And it had been undertaking work for years on trees without it ever becoming an issue. Never applied for TPO consent.
Wow.
Just didn't know it had a TPO. The estate manager had been there for 15 years. He didn't know about it.
That's
And
bad.
I think in 2017, the estate changed hand and it didn't come up in the conveyancing search. So there was some problem with how the TPO was recorded, because it wasn't spotted when this estate changed hands for many millions of pounds, probably tens of millions of pounds. And nobody knew about this TPO. Now, obviously enough, we all know ignorance is no defense, of course.
But I have to say, can I interject there about tree preservation orders? There are so many tree preservation orders which are, well, very, very old, and we know that the layout of the land can change, can be built on, trees die. I mean, really, there is no excuse, because all tree preservation orders should be reviewed. There was a real move on this about 10, 15 years ago, and I know there are lack of resources, but surely it costs so much in wasted time, everybody's time, the tree owners' time. This is a case where it should have come up in a land registry search, the tree officer's time, the tree owner's time. Really, I think it's unacceptable.
Yeah, no, it is. And these legacy orders, they need to be sorted out. The local authority should get a grip, absolutely. I mean, one of the worst offenders is Barnet. It's got lots of 1950s legacy orders that cover entire postcodes.
Yes.
You know, just crazy. And they've no idea what trees are protected. They really don't know. So going back to this case, obviously people should have checked. Well, clearly there were administrative problems with what happened, but it doesn't change the fact that the trees were being felled because they were genuinely considered to be unsafe. There was no gain involved. It was simply people trying to do responsible tree work. I mention this because this raises a very important question: was it in the public interest to seek to prosecute that offence? So as you know, there are 2 prosecutorial tests to which prosecuting authorities are subject. One is there a realistic prospect of a conviction? And secondly, is it in the public interest? And whatever one might think about realistic prospect of a conviction, clearly you'd have to ask the question about public interest. The contractors concerned were a firm of reputable landscape and tree contractors. They did a lot of work for the local authority. In fact, they're one of their leading contractors. No suggestion that they weren't a good quality firm doing good quality work, and good quality work in the public interest, maintaining school grounds and what have you. They decided they were going to press on. So when we got the decision in the Forestry Commission Highways England case that I was talking about a few minutes ago, we sought the opinion of the same barrister, who said that it was effectively identical in terms of the law, because these are trees that required a felling license. They were felled without a felling license, but that had timed out because it was a summary only offence, and we were well after the 6-month sell-by date of that particular prosecutorial reach. But there was no TPO consent applied for, nor was one necessary, nor could one have been granted for all the reasons given. Section 15.5 Forestry Act, the local authority couldn't have even entertained an application for consent had they received one. So there was no prospect at all of the case going forward, because abuse of process would have been applied for and no reason to expect it not to have been granted. So the local authority at that point said, well, actually, we're going to carry on. We're going to test this. We don't necessarily accept that this applies, because we think maybe the 5 trees that were felled don't together comprise the necessary 5 cubic meters of timber.
It doesn't take much, though, does it? I suppose, were they thinking of excluding, was it 2 trees that were in a very hazardous condition?
They never really got into the details of it. But from my point of view, if they accepted the trees were dangerous, then they couldn't prosecute for their felling. If they didn't accept they were dangerous, they required a felling license. So the local authority made noises about, well, the volume of timber. And it was then pointed out to them that, interesting quirk of the law, if you're going to rely on an exemption as a defendant, you own the burden of proof.
Yes, that's right. Yeah.
The standard of proof, of course, becomes the balance of probability in a reverse burden of proof case, not the criminal standard of beyond reasonable doubt. But conversely, the local authority, if they were to say, well, actually, the volume of timber was insufficient to trigger a license, they would then have had to prove that.
Yes.
And they accepted that at that point they couldn't prove that. So that prosecution was also dropped. The main thing, of course, about the second case is they accepted the law as being correct from the first place. So we now have a chain of logic now that goes, a court has handed down a decision that validates the interpretation of the law that we had advanced. And then in a second case, a prosecuting authority, which actually was led by a barrister, also accepted that interpretation of the law. So it's now, I think, really beyond any plausible doubt that if you have a tree that's felled that either has a felling license or doesn't, but needed a felling license, and if that tree is subject to a TPO, the local authority do not have jurisdiction to prosecute under the tree preservation order. And the reason I make this point and labour it is A, to assist other people potentially faced with this situation, and B, because absolutely shockingly, the Forestry Commission has still not withdrawn Operations Note 52. So it's still up on its website giving the wrong advice that has been falsified in court, and they're still maintaining that position. Quite remarkable.
Good heavens. So lots of things to say about that. First of all, presumably there are a number of cases, we don't know how many, where people have been prosecuted for a contravention to a tree preservation order, where they've been prosecuted for felling a tree protected by a tree preservation order, which would have required a felling license, irrespective of whether or not a felling license was applied for or granted. So there are people now who have a criminal record that they would not have had. Is this a miscarriage of justice, Julian? What do you think about that?
I think it can only be a miscarriage of justice, because if the prosecutions that led to their conviction were essentially an abusive process of the court concerned, albeit one that was not recognised at the time, then those convictions must surely be unsafe. That is certainly the view of members of the legal profession I have talked to on this point. And it's worth just dwelling briefly on on what this means. So if you are a habitual or otherwise career criminal, then it's my understanding that you accept the processes of the law as a cost of doing business. If you, however, you're the ordinary citizen who, for whatever reason, has been prosecuted for felling a tree with a tree preservation order on, chances are you've not done it for gain. Chances are you've done it out of an administrative error or a misunderstanding of how exemptions apply or whatever it happens to be. Guilty still of contravening the TPO, apparently. But if in the cases where the Forestry Act trumped the Town and Country Planning Act, you've been wrongly convicted under the latter, what has happened to you? So you've got a criminal record, so that means you can't emigrate to many countries that you might want to emigrate to. Well, maybe that only catches a small number of people. But what if you have a job that relies on integrity and trust, like, for example, you're a solicitor, and you've lost your job as a result of that. And then you can't pay your mortgage, so you've lost your house. Or maybe it's caused relationship strain and your marriage has broken up. And all these downstream effects from a correct prosecution are, unfortunately, the consequences of breaking the law. But where that prosecution was made incorrectly, then that's very much a burden on the citizen that they shouldn't be asked to bear, and for which I imagine compensation will be due.
So the human cost of this as well, you talk about the emotional cost, the potential loss of employment, the potential loss of your property, the harm done to your own health caused by stress, the harm done to any relationships. I mean, this podcast is not advocating unlawful felling of trees, but when you look at the law and you see that there is a miscarriage of justice and the human cost of that, I wonder what's going to happen in the next few years. Might there be a number of cases coming back to court under miscarriage of justice? And might that result in a lot of compensation being paid?
Well, I think that is likely. The first tree preservation order prosecution I ever worked on, I was expert witness for the prosecution, and 3 people were convicted who, with this understanding of the law as it now is, should not have even stood trial. One of whom was, in fact, a solicitor working for a government department, and he did indeed lose his job as a result of his criminal conviction. So I know this is real. I know this happens from my own experience. The firm of solicitors acting for the defendant in both cases, the well-known firm of Goatley's, they are actively looking into the potential for miscarriages of justice, and if anybody listening to this podcast feels they may have been a victim of such, they should contact you, or I can be put in touch with the correct people to look into this further.
Yes, we can pass it on. Just in case anybody's wondering, they might be listening to this thinking, well, is there any point in putting a tree preservation order on a tree outside of somebody's garden or working orchard or churchyard? Well, of course there is, because you do not need a felling license to prune a tree. So the tree preservation order protects it in that way.
Exactly. Lopping or topping absolutely are outside the scope of the Forestry Act. And the felling license is for felling. And if, for example, you got a bulldozer and pushed over a tree, that might be felling, but maybe one could have a conversation about whether or not it is felling. Similarly, if you pollarded it, that wouldn't require a felling license. So TPOs still do have a place. But if you are, for example, a local authority contemplating putting a woodland tree preservation order on to stop the woodland being felled, maybe thinking twice about that as to whether or not it's a necessary tool. It does, of course, get you buy-in as a consultee. Yes. Should do anyway, on the felling license application. So for that reason, potentially, it is worth doing.
It seems to me that just more generally, there should be more collaboration between tree officers and the Forestry Commission. Imagine if they actually regularly had conversations. I'm sure some do, but again, we all work in silos. I'm very heartened by the good work of the Association of Tree Officers and the London Tree Officers Association, and I see different groups of tree officers sort of working together. That's really, really important to get good practice, because when you are that tree officer, you may be the only person in that local authority, and boy, are you busy. So really to have all of that support around you from others to find out what is current changes in the law, but in this case, there's no change in the law. It's been brought out into the open and made very clear. But I know in my daily work that there are still tree preservation order approvals given to trees which actually need a felling licence.
I see a really important role here for the Institute of Chartered Foresters. It is, of course, holder of the Charter for Arboriculture and for Forestry. It is therefore absolutely in the right place to bring together forestry and arboriculture law, as it were, and an understanding of it. It is a source of regret that more tree officers are not chartered arboriculturists, i.e. members of the Institute of Chartered Foresters. Hopefully that will change over time. I know that several already are, but we need more, particularly senior officers, heads of department, as it were, to be members of the ICF, and to try and therefore the ICF can try and bridge this gap to make sure that those operating within arboriculture understand the law of forestry insofar as it applies to them. And I think that's a really important point.
Well, we hope to bring out technical membership later this year, which will encourage all levels of people working in local authorities who are all working incredibly hard. So it's about this dissemination of information, which is really, we're so grateful that you've come on this podcast today so that we can get this message out there and really just help people work effectively to protect trees in the right way, to make sure that people, if they work in private practice, that our clients understand the felling licence regulations, because there's still a lot of work to be done there. People still want to clear fell a site. I went to a site recently within an urban area, and the client said he wanted to clear fell the site. And I said, well, you would need a felling licence. He said, what's one of those? And this is somebody who's in their 50s, has always worked in construction at a very senior level. So I hope that out of this, that people learn, that people talk to each other more. But I'm very saddened by the miscarriages of justice and the human cost of this. And I'm also concerned about the actual cost of this to hard-strapped local authorities that may come forward. I mean, a miscarriage of justice is a miscarriage of justice and it needs to be dealt with, but we also need to think about the consequences of that as well. Do you see the picture improving?
I'd like to say yes, but unfortunately, I think it has become clear in this episode that the Forestry Commission, particularly the regulatory affairs aspect of it, is in urgent need of reform. I think that is the reality. The fact that they have maintained, despite me writing to them and pointing this out, that same wrong advice in their Operations 15, the fact that's still current is quite remarkable. The fact they're still maintaining that felling licenses run with the applicant, not the land, when that's contrary to all their published guidance and has no statutory basis whatsoever. These are matters of very real concern. And if you are a regulatory authority, you have an 100% cast iron public duty to administer the regulations fairly and reasonably. And what you can't do is act in this capricious, we know best sort of way that just ignores the realities of the regulatory framework that you're supposed to be operating. So I think that unless or until there is form of the Forestry Commission, I think things are going to be difficult. Now, I am going to take this forward. Happy to say now publicly that next month, when my current immediate deadline of expert evidence has passed, I'll be starting a formal complaint with the Forestry Commissioners into all of this to look at why that felling license was granted with a known abrogation of regulations, and why Forestry Commission went into writing to say there was no felling license applying to the land in question, etc. And all of this I'm going to put to them and ask them to look into it, because I think that's what we need now is a proper inquiry into the conduct of this particular department, so it can hopefully put its house in order. That hopefully then will lead to some improvements.
I really hope that there can be a workshop about this with all interested parties to have an open discussion. The law is the law, but I also think of the human side of that, of people learning and working together more. I hope that happens, and I'm going to be thinking about that to see what we can do. so that people feel that they can move on from this in a really helpful way?
This would have been a very salutary experience for the local authority, having to shell out more than £100,000 in costs. But the mental health of my client suffered very, very significantly.
Of course.
The reason I have not mentioned any names is so that I can actually say that he had to be sectioned under the Mental Health Act as a danger to himself. Was on very significant amounts of medication, that's a terrible position to be put into, because he knew that he'd done nothing wrong, and yet he stood to lose really quite a considerable amount, well above and beyond just a fine or whatever. That's why local authorities contemplating, or any prosecuting authority contemplating prosecution, need to think very, very carefully about the public interest test, and of course to make sure their ducks are properly and legally in a row before they start the ball rolling. I've represented a significant number of defendants now facing TPO prosecution, and not a single one has been convicted in the court due to quite significant gaps in the prosecution or the cases being pulled before they get there. And my strong suspicion is that local authorities are not looking hard enough at the two prosecutorial tests before they press go. And that's something I would absolutely urge them to do.
I'm going to flip that. And I'd say there's also a problem of great under-resourcing of local authorities' enforcement officers and tree officers. And there are offences taking place, albeit maybe not with tree preservation orders, but general planning lapses in protection of trees, which nobody has the time to pick up on and actually should be picked up on. So it's a very polarised and disjointed picture across the nations, and it's not all that local authorities are prosecuting too much. Sometimes they're not prosecuting enough. Sometimes they simply do not have the resources to see what's actually happening. It's a very, very patchy picture. Lots of people are not looking after their trees correctly. Julian, thank you so much for joining us.
You're welcome.
This will spark lots of debate and discussion. If people want to find out more, where should you direct them? Forestry Commission website?
The Forestry Commission website.
Well, I would like to sort of counter that and say that the actual felling licence guide, getting permission, I think is very clear.
Yes, that is a good place to start. We just need to straighten out this one particular piece of guidance, and when that's done, then they can go to the Forestry Commission website, but not until they have revised Operations Note 52. The date is 15th of July 2020. So if people see a date from this year, then hopefully that'll be correct. But if in doubt, you could always ask you or I.
Hit the subscribe button to guarantee you don't miss an episode, and you can follow us on
Twitter at the Tree Lady 67,
Instagram Tree Lady Talks,
Facebook Sharon Hosgood Associates,
or send an email to noel@treeladytalks.co.uk.
Thank you very much for your time, Julian. It's been a pleasure to talk to you again.
Nice. And Sharon, I believe this may be, at least for the moment, the last Tree Lady Talks podcast. So thank you very much for all you and Noel have done, bringing these podcasts to your audience. Many arboriculturists and beyond have had dozens of hours of happy listening. So thank you both very much.
Thank you, and much appreciated.
Well, thank you very much, Julian. It's very nice of you to say so. We've certainly always enjoyed doing all the episodes of the Tree Lady Talks podcast. It's been great fun, hasn't it?
Absolutely great fun.
So in the meantime, it's goodbye from me.
And it's goodbye from me.
If you're from the Forestry Commission and would like the right to reply, please get in touch with Noel at treeladytalks.co.uk.